Important to understand the concepts of mobility and marketability, because when you talk about goods, subject matter is goods, the goods should be basically mobile. And when you talk about levy, if you want to impose duty, it should be marketable. So let us take each concept. Let us go for concept first. What do you mean by mobile goods? Movable goods. Movable goods here means goods capable of being shifted from one place to another place. So these are shiftable goods, or you can say portable goods, portable, shiftable. So these, if anything can be shifted from one place to another place easily without any damage or injury, then they are movable. Otherwise, they are not goods. Okay. Only movable property, I will call it goods because it should be specific. Only movable goods are subject to levy under excise. And what about others? They are not subject to levy. Only movable goods are subject to levy under excise. What about immovable property? No. Hence, it is essential to know, it is essential to understand the concept clearly. It's not possible. Otherwise, it is where we end up, we don't know. So, goods capable of being shifted from one place to another place are called movable goods. Only movable goods are subject to levy. Immovable? No. Immovable means it is not goods. Hence, it is essential to understand the concept clearly. So, conceptual clarity is possible only when you get it. See, let us see how it is so important. It can be understood only with the help of case study. Case study will help you understand better. For example, item X is there and it can be shifted without injury or damage or demolition, something like that, then it is goods. Then it is movable. Anything fixed or fastened to earth or embedded in earth which cannot be shifted as it is. As it is means as such. It cannot be shifted as it is without disturbance. without damage, major damage, minor damage is okay, without major damage, then what it is immovable. You can say this is immovable. So not accessible. Mobility and mobility and accessibility, this is the basic thing. Okay? So this you have to understand carefully. Suppose there is a duster in my hand. This duster I can shift from one place to another place. Is there any damage? There is no damage. So this is mobile. Suppose this table is there. This calculator is there. Is there any damage if I shift from one place to another place? No. Suppose there is a fan, ceiling fan. The ceiling fan, I remove and put it somewhere else. Is there any damage? No. So when there is no such damage, then it is a case of movable property. Suppose there is a damage, it is a movable property. See conceptually how easy and simple it is, but you see the case study. Let us look at the case study also. So a little case study is necessary to understand the concept. Look at this. There was a case, Triveni Engineering and Industries Limited. (2000) Supreme Court. This citation irrelevant, but only just to inform you, I am giving. It was a case in 2000 decided by Supreme Court. Triveni Engineering and Industries Limited. It's against Central Excise Department. The other part is Central Excise Department, so we don't mention that. So Triveni Engineering and Industries Limited. In this case, the product was a turbo alternator. So this turbo alternator is nothing but a generator, electricity generator. Electricity is generated from this. How? See, a platform is created. A platform is made, and there are two major components here. One is, you can say, a turbine. This is turbine. This is manufactured by the company, and excise duty is paid, and it is brought to this place where a customer requires a plant, electricity plant. And another device is, say, generator. This generator, this company is procuring from BHEL, Bharat Heavy Electricals Limited. So the platform is created, and these two parts are put here. And what is happening here is, with these two major components, there is a lot of alignment taking place, accessories, everything added, and finally the product, that is turbo alternator, is made. The entire unit is called turbo alternator. It's a combination of turbine and alternator plus. And it is fixed. Now the issue. It's a very important issue. Whether this turbo alternator is accessible. It is accessible only if it is movable. So can you tell me whether it is accessible or non-accessible? So if it is movable, it could be accessible. The process is manufactured, no doubt, because you are taking two major components, and finally you are making it into a turbo alternator which is operational. Once it operational, it generates electricity. Say mechanical energy is produced here, and that mechanical energy is converted by generator into electrical energy. So some fuel is added here, put in, and mechanical energy is produced, and from that electrical energy. That's it. So it is in industries wherever there is a power cut, then this is put to use and there is uninterrupted power supply. Done. So everything is okay. Whether this is movable or immovable. Department says this is movable. The entire unit is a manufacturing process and finally excise duty is payable. So company says this is fixed. Everything is fixed. And if you remove, you will get only generator and turbine. On turbine you have already paid excise duty, on generator you have already paid excise duty. What is extra? The value addition. So once the value addition has been made here, it is in an immovable state. This is a construction activity resulting in immovable property. So no excise duty is payable because this is not goods. So what do you say? What is your conclusion? The Supreme Court said this is a case of immovable property. Why this is immovable property? Tell me why this is immovable property. Because the Supreme Court said if you dismantle it, this turbo alternator as it is, say first statement of the Supreme Court was the turbo alternator cannot be brought to the market to be bought and sold. This cannot be brought to the market to be bought and sold as such. As such means as it is. So it cannot be brought as it is. So it requires a dismantling. When you dismantle, you get turbine and alternator. In one hand it is turbine and in another hand it is alternator. It is no more turbo alternator. So turbine and alternator already suffered excise duty. So when you dismantle it, it is turbine and alternator, no more turbo alternator, and hence it fails the test of marketability. Suppose you can lift it as it is, you can take it to market as it is, you can sell it as turbo alternator, it is okay. If you try it, you have to dismantle. Once you dismantle, all these things will go, only two components remain. So Supreme Court said anything which cannot be brought to the market to be bought and sold as such without dismantling, if you can't bring it, it is immovable. So this is a case of immovable property. And in fact, earlier also, to explain the concept a little better way, Supreme Court in one case, very interesting case, that is Municipal Corporation of Greater Bombay. Municipal Corporation of Greater Bombay, this was a very important celebrated case. In this case, Supreme Court applied permanency test. What do you mean by permanency test? The permanency test says if your intention is to make something a permanent thing, permanently attached to the earth or attached to something which is already attached to the earth, like that, if you feel like having some permanency, then it is a case of immovable property because it cannot be shifted. Because your intention is to make it permanent. So you can't shift it. If you shift it, it is not possible to get in the same position. So if your intention is to make it a temporary arrangement, so how do you fix it? So that you can remove comfortably. So intention is to be looked into. Here, if you look at the intention, they wanted to make it a permanent attachment. It is not under nut and bolt so that you can remove and lift it. So Supreme Court said this is an immovable property. So excise duty is not payable because when the turbo alternator came into existence as a whole, it is in an immovable entity. Hence, not excisable. So very interesting case. And after this, see, anything attached to the earth, there has become a big rule, good rule. So anything attached to the earth means it becomes mobile only when it can be lifted or when it can be removed as such without any damage or dismantling. Otherwise it is mobile. Otherwise it is, if you can lift, it is mobile. If you cannot lift as it is immobile. In this case, turbo alternator as a whole will not come into your hands. Only the parts of the turbo alternator. Hence, it fails the test of marketability. Sorry. It fails the test of marketability, hence it is, because it is not mobile. Anything which is not mobile is not marketable. Because under excise, marketability is an important test. Look at another case. Maybe it is of interest to you. Solid, correct and engineering works. Solid, correct and engineering. Works. This is a case in 2010, Supreme Court. This is also a major, one of the major cases on mobility. In this case, the product is asphalt drum mix plant. Asphalt drum mix plant, ADMP. This is known as ADMP. So this asphalt drum mix plant, this is for road laying. To lay roads, we use tar, that is called tar coal, chips, stone, chips, and it is tar coal is heated up and mixed up with this. See, it has three components. One is 4 bin combination. Bins are there, like bin number 1, bin number 2, bin number 3. Bins to keep the metal or material. 4 bins are there, and dryer is also there. So this is, dryer is set up under nut and bolt. So there is a foundation here, cement blocks are there. On cement blocks, it is fixed. And also conveyor. Conveyor to carry the metal. Conveyor belt is there. So like this, bins, dryer and conveyor belt. It is in 3 parts. But as a whole, the setup is, it is fixed on cement blocks. But here it is under nut and bolt. Fixed under nuts and bolts. So once the road work is complete, what they do, they are removing this nut and bolt. Cement blocks are there, but these are removed and lifted by a crane with the help of a crane, and they are taking away to some other place and they are putting as elsewhere. Means once the work is over, they are removing all these parts and taking away. Now the question is whether this is mobile or immobile. If it is a mobile property, excise duty is payable. If it is immobile, no. Company says this is immobile. So very big, like that. Department says this is mobile property. What do you say? Here, entire thing is in 3 parts, and it is under nut and bolt. What is your intention? You are removing and you are using the same thing elsewhere. Where is the damage? Small damage is there, but substantial damage is not there. So what is your intention? Your intention is to make it temporary. That is the reason why under nut and bolt you have fixed and you are taking away. So this is a temporary arrangement. So this is a mobile property. Excise duty is payable on this. So if you compare Triveni engineering case and this, it was temporary, it was permanently fixed to the earth. And if you want to dislocate, you have to dismantle. So there will be substantial damage. Here there is no damage. Small damage is there, but the same three parts are useful somewhere else and they can be fixed. Suppose your intention is to make it permanent, permanently fastened to the earth, then this becomes immovable. But you have put it under nut and bolts. Right? So Supreme Court said you have already removed this, you are removing and shifting from one place to another place, and you are having the same arrangement. See, the unit of these three components is a excisable product. Excise duty is payable. You can't say this is immovable. So permanency test, if you apply permanency test, you will come to this conclusion. Suppose earlier we are talking about Triveni case, Triveni engineering case. So in Triveni engineering case also it can be mobile, it could be mobile. Suppose they had a permanent structure or platform. Suppose on the platform, suppose they have some wheels. So if it is under wheels, Triveni turbo alternator would also become mobile if it is under wheels. But what they have done, not under wheels or not under nut and bolt, they have permanently fastened to the earth, permanently fixed to the earth. That is the reason why that was not, that was immobile property and this is mobile property. So do a little more research to understand. Okay? So without damage, if you can shift it to some other place, that is mobile property. Some damage occurs, particularly substantial damage occurs because of shifting, then it is immobile property. So you are disturbing, you are causing injury. So voluntarily it's moving means it can be shifted that way, means it is mobile, otherwise it is immobile. Okay? So mobility, immobility, that we have to examine very, very carefully. The line of distinction is very limited, very little. So anything, certain things can be mobile and at the same time immobile. Okay? So I draw a few points. Mobility is a question of fact. Anything which can be shifted from one place to another place is mobile, that we have already examined. Is a question of fact. Why question of fact? Suppose air conditioner. Air conditioner mobile or immobile? It can be both. Suppose system or centralized AC is immobile. Do you agree? It is immobile. Suppose unit or split AC, air conditioner unit, this is mobile, unexcisable. Centralized AC immobile, car AC immobile, whereas this is mobile. See the difference? Same air conditioner. Similarly, you can say water tank. We may have overhead tank, syntax like that. Water tank. Permanently fixed means permanently attached or fixed with concrete, cement, concrete, etc., etc. This is immovable. And temporary, just under nut and bolts. So we purchase water tanks, syntax tanks, etc., etc., and we attach under nut and bolts. So this can be shifted. So this is movable. Similarly, nowadays houses, living places for shootings, etc., etc., some temporary arrangement is there, something like house is built, temporary. So once the job is over, they lift it away, take it away. The house may be immovable or movable, depending upon how you have made it. Anything, even furniture, anything. So that is the reason why mobility is a question of fact. It's not a question of law. Based on the facts of the case, you can judge. Otherwise, no. Things attached. attached to the earth. You can say some machine is attached to the earth, plant and machinery erected at site. You have to examine whether it is mobile or immobile. You can lift it, you can take it, you can bring it to some other place without damage or dismantling, or with small damage or limited damage, then it becomes mobile. Substantial damage means it is immobile. So, mobile or immobile, there is a thin line of distinction or difference. You have to examine whether the goods are mobile or immobile. If they are mobile, excisable. If they are immobile, no. Okay? That's all about mobile property. Only mobile property is subject to excise duty under excise. Immobile property is not. So, this you have to understand. Okay? Then marketability. Marketability means saleability or suitability for sale. Anything fit for sale, use or consumption is marketable. See, anything produced or manufactured, whatever it is, which is fit for sale, use or consumption. Fit for sale, use or consumption is marketable. If the two conditions are satisfied, I put here two conditions. If the two conditions are satisfied, what are the two conditions? Very important. Condition number one, the produced item, I write here. Condition number one. See, this, whatever I am speaking here, whatever I am talking here, whatever I am writing here, is in a nutshell. It's very important based on a lot of research. Number of years research has gone, and finally, whatever the Supreme Court has decided on various cases regarding marketability, in a nutshell, it is in two parts. If you apply these two tests, then you will clearly understand marketability. Nothing else is required. You see, for example, one, the thing produced must be a product or goods, you can say, you can call it goods. It must be a product known in the market. This is called trade parlance test or vendibility test. Vendibility test or trade parlance test. What do you mean by vendibility? Saleability. Trade parlance test. I call it trade parlance. So trade parlance test means people in the trade, consumers, manufacturers and traders, they should know that there is something like there is a product. So what do you mean by product? Product has certain features. What are the features? Product number one, it has a name and it has some features. It has some features and it has some specified purpose or use. So, suppose this is marker pen. So, marker pen is known, manufacturer understands that this is marker pen. Trader understands this is marker pen. Consumer understands and he purchases. So, with what mind he purchases? For the purpose of where it is useful, it is known. So, marker pen is a product known in the market. Okay? So it is purchased. But with what intention? Because it is written, it is useful as a writing instrument. On whiteboard, it is useful. You can write something. Okay? So product. Number 2, it must be sold, bought and sold. What it means? It must be sold or capable of being sold, or capable of being bought and sold, to be more clear. Capable of being bought and sold. If these two conditions are satisfied, then you can say this is marketable. Otherwise, no. You go through these two statements, read and read again. I'm not in a hurry. Read and read again and try to catch the point. I will elaborate. And I will explain. Of course, I will explain with the help of case study also. Here, at this level, a little case study is also necessary to substantiate. First point, for example, produced must be a product known in the market. Suppose you have produced simply because, say, fit for sale, not fit for sale, say fit for use or consumption. Simply because it is fit for use or consumption, it is not enough. Having utility is not enough. So many things have commercial utility, but that entity should be known in the market as a product. So it should be a product. Okay? So look at this. I'll give you some examples also. I can give you. First point. Must be a product known. Suppose you have produced something. It has commercial value. It has use value. Still, it is not known in the market as a product. Then what happens? There is nothing. Say one case, very, very famous case, that is DCM Limited. This is father of all cases under basic concepts. Under excess, until and unless you understand this case, you can't go into the details of basic concepts. So for basic concepts, this is a very important, most important case. In this case, what happens? Briefly. The company was putting input and they are producing intermediate product. And then final product. Okay. So far, so good. Intermediate, what is the input? Till and groundnut oil. Till and moongfali oil. That is till and groundnut oil. And they are making processed oil. Natural. They are processing, so you are getting processed oil. And from this processed oil, they are also further putting it into process vanaspati, or you can say dalda. The product is known more by the brand name. This intermediate product, there is no dispute about this. This intermediate product, this processed oil, whether this is a product marketable and accessible, leviable or not. The government is very particular. It says this is a non-essential vegetable oil. Non-essential vegetable oil, so you have to pay duty. But the company rejects. Company says no. This, you say non-essential vegetable oil, but this is not bought and sold, not known in the market. Not known, so nobody buys or nobody purchases. Why? They have given a reason also. Whatever processed oil, vegetable oil is available in the market, that is without smell, that is after deodorization process. What do you mean by deodorization process? This is some process which removes the smell that is emanating from this processed oil. There is some smell, so remove that smell. After removing that smell, the product becomes capable of being bought and sold. So that somebody can purchase and use it to make curries or any preparation. So it becomes eatable only when you remove the odor in it, because this is in crude form, this is somewhat in a refined form, but with the same smell. Until and unless you remove the smell by the deodorization process, this is not fit for consumption. Nobody buys it. So until and unless you do this process, it is not marketable, not known in the market as a product. So this is not saleable in this condition. Yes, Supreme Court agreed. Yes, Supreme Court said this is not a product known in the market. In this condition, nobody purchases. Nobody uses for making any process to make any curry or any preparation. So it becomes eatable only, edible or whatever it is, it becomes consumable only after the deodorization process. And before that, it is still giving the smell. With this smell, this is not known in the market as a product. By what name you call it? Is there any name for this? Is it bought and sold? No. The Supreme Court said no. This is not marketable in this condition. So this is not a product. So this is a product, but this is not, because it is not marketable in that condition. So not known, anything not known, no doubt it has commercial value, it is useful, it is further put into process and some useful product is being made. Simply having commercial value or economic value is not enough. It should be a product. It is not a product. It should be a distinct entity. It is not. And I can give you so many examples, but one more example I would like to give. So there was a case called Bhor Industries. So in Bhor Industries, what was happening? See, you can say in winter they wear Rexin or resin. Some granules are put into process, and resin or Rexin, you can say, leather coats, something like leather coats, artificial leather, of course. They are PVC crude films. They are making PVC, they are called, that product, intermediate product is called PVC crude films. These PVC crude films are, PVC granules are converted into PVC crude films, and these PVC crude films are further put into what you can say, garments, leather garments, resin or Rexin garments. So in winter, these are used. These look like leather garments only, but artificial. So the question is, these PVC crude films converted into resin garments, whether this intermediate product, whether this intermediate entity is a product under excise to be leviable. This concept is same. The PVC crude films in their crude form, it is not bought and sold. Nobody buys and nobody sells. This is not in that condition to be bought and sold. So this is not a product known in the market. So this is a product, this is not. So this is not leviable, because this is not a product, because this is not marketable. This is not marketable because this is not known in the market as a product to be bought and sold. Okay? So I will go for, so very interesting. Marketability concept is a very interesting concept, and of course manufacture is more interesting. So I will take you, so PVC crude films is having commercial value, economic utility, it is further used, but still it is not marketable because it is not known in the market as a product. And recently there was a case called Cipla. Of course, 2008 Supreme Court. In CIPLA, BMS, there is a chemical substance called BMS. Some technical name is there, salicylate, something like that. This is a chemical substance, resultant chemical substance, released, produced, incidental. It is being produced incidental to what you can say, the process of manufacture. Say they are manufacturing drugs. In drugs manufacture, incidentally, BMS is also being produced. You can say byproduct, waste product, something like that. So this BMS, about this BMS in a journal, you can say drugs journal or magazine. Drugs journals are there now. In drugs magazines, it was specified as intermediate product. Simply like that. So BMS is an intermediate product. That was mentioned. That's it. Based on that, and in fact, what is happening? The company, of course, the company is manufacturing drugs and it is selling and is paying excise duty. On BMS, it is not paying excise duty. In fact, even though this BMS, it is taking to other units. It has some other unit in Maharashtra, I think Patal Ganga, something like that. And there, this BMS is used elsewhere for producing something. It's not that they are throwing away. It's not a waste product. They are not throwing away. They are taking it to some other unit and they are using it somewhere else. So, department, obviously, what the department says in drugs magazine, it was mentioned as an intermediate product. And this is also being used, not throwing away. So, this is also a product. BMS is a product. It should be excisable and it is marketable. So, duty is payable on this. Not only on this, but also on this. Because they are producing BMS also. And company says this is not excisable. Means not marketable in our language. Why this is not marketable? This is not known in the market as a product. Nobody buys or sells. So prove it. Because whenever there is a controversy, the burden of proof lies on the department. The department has to prove. So prove it. This is not known in the market as a product. This is not bought and sold. So in fact, department tried. In fact, at lower level, department won the case and the company appealed before the Supreme Court. So earlier, the tribunal, CSTAT, decided based on this is an intermediate product, so this is marketable. But CIPLA company challenged it in the Supreme Court. Directly such cases go to Supreme Court. So the case went to Supreme Court straight away from CSTAT and Supreme Court examined. The company challenged simply because it was written as an intermediate product. So do you say that every intermediate product is automatically marketable? No, not necessarily. Say if that is the case, in DCM Limited case it was intermediate product, not marketable. In Bore Industries, PVC crude films, they are intermediate product. See, for excise, intermediate product, the concept is irrelevant. Is it a product known in the market to be bought and sold? Yes, this is marketable. Otherwise, no. I will give you one example. For example, some inputs you are putting and you are manufacturing something called compressor. Say, let us take the refrigerator industry or air conditioner industry. Say, refrigerator is made. Refrigerator is made. So, in refrigerator, you use compressor. Backside, you see. So, compressor is an intermediate product. Okay? So, even oil in crude form is also intermediate product. But what about this and what about PVC crude films? Under Bore Industries case, PVC crude films, they are also intermediate product. Compressor is also intermediate product. What is the difference? See, the compressor is a unit. It is capable of being bought and sold. Even if you don't make refrigerator, you sell it away as compressor. There are buyers to buy this compressor. But what about this? Both are intermediate products. Whether it is intermediate product or final product is irrelevant. It should be known in the market as a product. It should be capable of being bought and sold. This compressor is known in the market as a product. Maybe it is used in refrigerator as intermediate product or as a component, or maybe it is used in air conditioner. Still, compressor is a compressor known in the market as a product. So this is accessible. But this is not accessible because there is no takers. If you have takers, then it becomes. So, the Supreme Court. What is the decision of the Supreme Court in Cipla case? In Cipla case, in fact, the department tried how it wrote a letter to Customs Department to find out whether such a chemical called BMS is being imported or exported. Is there any history of import or export? No. Next. In India also, this is not bought and sold. There is no history that it is being bought and sold. Then, finally, the Supreme Court said, you failed to prove. You prove and you get it. You fail to prove that this is marketable. Is there anybody who buys and sells this product? No. So you fail to prove that this is bought and sold. There is no history that somewhere it is bought or somewhere it is sold. So this is not marketable because this is not being bought and sold, because it is not an entity known in the market for a particular purpose. Even though it is used, this is not marketable. In most of the cases, department fails to prove, automatically department loses the case. Simply because an entity is there, it doesn't mean simply because it is used somewhere, it has some commercial value. You cannot say that it is marketable. It should be known in the market as a product also. If it is not known in the market, it's not. Okay? So, similarly, there may be a product. Second part, I am talking about second part. It may be a product known in the market, bought and sold, but this particular product may be not merchantable. Or under Sale of Goods Act, we study the concept of merchantability. Not merchantable or not capable of being bought and sold. Then what happens? I can give you a simple example to explain the concept. Need not go into case study. Of course, there is a lot of case study. Suppose, take the case of Cipla or any manufacturing company. Suppose medicines are manufactured. Drugs. Often it happens, sometimes due to some manufacturing defect or formula, something like that, they go wrong. So it is very risky and dangerous. The people will go behind bars. Suppose there is some problem with the formula, and because of that formula, what happened is, drugs not fit for consumption. So if somebody consumes, it has become poison because of some defect in formula, something like that, change in problem with the formula, not fit for consumption. It has become poisonous, so thrown away. The company, entire batch, they have thrown them into dustbin. They did not market. So this is a product known in the market, but because this is not fit for consumption, this is not capable of being. Because this is not fit for consumption, this is not capable of being bought and sold. Even though this is a product, this is not marketable because it is not capable of being bought and sold. So, if both the conditions are satisfied, it should be known in the market as a product, and it should be either bought and sold or it should be capable of being bought and sold. Okay? Suppose marker pen is manufactured, but this marker pen, because of some defect, it is not writing. So once it is not writing, this is not marketable. Even though this is a product, it has a name, whiteboard, Luxor company, refillable, and everybody knows that this is meant for a particular purpose. This is used for writing on the whiteboard, but this particular batch of pens, it is not writing. So it's not capable of being bought and sold. This is not marketable, even though this is a product. So it should be a product, and it should be bought and sold or capable of being bought and sold. Then the conditions are satisfied. Even if they are short shelf life, there is no issue. Even short life goods can be marketable. Say, I'll write down some other important points of marketability. For example, no distinction. Say, even scrap, waste, byproduct, joint product, etc. can be marketable. So you can't say scrap, waste, byproduct. Some certain scraps, they are not marketable. Certain scraps are marketable. If the two conditions are satisfied, they are known in the market as a product and they are capable of being bought and sold. Otherwise, no. So even short shelf life goods, short life, maybe they last 2 days, 3 days, like that. Short shelf life goods are marketable. If they are bought and sold, are capable of being bought and sold in their short life. So it depends, case to case. In certain cases they are not marketable, in certain cases they are marketable. Case to case basis. So it's because it's a question of fact. Number 3, even one buyer is enough. Single buyer, need not be number of buyers. And marketability is independent test. Marketability is an independent test. So you have to test simply because a particular there is a manufacturer, you can't say that it is marketable. Simply because it is there in the tariff act, you cannot say it is marketable. So it should be in the tariff act. There should be a manufacturer, but at the same time it should also be marketable. All these conditions should be independently satisfied. You cannot assume simply because there is a manufacturer it is marketable. You cannot assume simply because it is in the tariff act it is automatically marketable. No, sorry. Marketability is an independent test, and marketability is a question of fact. Based on the facts only you can decide. And marketability is not actual sale. Marketability doesn't mean actual sale. Even salability is enough. Actual sale is not enough. Whether actually it is being bought and sold or not is not enough. Capable of being bought and sold, it is fit for being bought and sold, it is enough. The actual sale is not necessary. And mobility is essential for marketability. Mobility is essential for marketability. Suppose there is no mobility, there is no marketability. Okay? And you see, if all these conditions is a question of fact, so burden of proof very important. If the marketability is in question, burden of proof lies with the department. Department has to prove. SSC need not prove. If the department fails to prove, sorry, the court simply will say, no, this is not marketable. Or you prove it. Okay. So it's not a question of law, it's a question of facts. If these conditions, these are the different parameters. There are other parameters also through case study, because the subject is always dynamic. When it is studied with case study, it becomes dynamic. So basically, conceptually, this is marketability. And if you go into case study, and we will see the same thing in different angles. Okay? So mobility and marketability that we have been discussing, and we have discussed actually, and other things we go into in the next. Thank you.